If you become incapacitated tomorrow, stroke, accident, sudden illness, your spouse cannot access your bank accounts, your adult children cannot pay your bills, your doctors are legally prohibited from discussing your medical condition with your family without your consent, and you cannot give it because you are unconscious. A court will have to appoint someone to manage your affairs. That process takes months, costs between $5,000 and $50,000 in legal fees, and the person appointed may not be who you would have chosen. This happens to families every single week. Every single one of them thought it could not happen to them. The document that prevents all of this costs between $100 and $500 to prepare with an attorney. Most people do not have it. I am Marcus Webb, and this is Benefits Decoded. Today we are covering powers of attorney, what they are, what happens to your family when you do not have one, the two types you need and why both matter, the mistakes people make when setting them up, and your 30-day action plan. Before I explain how this works, I want to tell you about a woman named Diane. Diane was a 71-year-old retired teacher in Florida. She had a revocable living trust, a will, and a healthy retirement account. She had done everything her financial advisor told her to do. What she did not have was a durable power of attorney. In March of last year, Diane had a severe stroke. She survived, but she was in the intensive care unit for 3 weeks, and then in a rehabilitation facility for 4 months. She was conscious, but not able to manage her financial affairs. She could not sign documents. She could not authorize bill payments. She could not direct her investment accounts. Her daughter, Karen, tried to pay Diane's bills. The utility company refused to speak with her. The mortgage servicer refused to speak with her. The bank refused to give her access to Diane's accounts. Karen tried to get information from Diane's doctors about her treatment plan and was told that without written authorization, they could not share anything. Karen hired an attorney and filed for court-ordered guardianship in Hillsborough County. The filing fee alone was $700. The court appointed an independent guardian ad litem, a neutral third party, to investigate and report to the judge. That person charged $150 per hour. A hearing was scheduled for 11 weeks after the filing. In the meantime, Diane's mortgage went 30 days past due. Her homeowner's insurance lapsed. One of her investment accounts triggered an automatic rebalancing that Diane would never have authorized. The guardianship was eventually granted after 14 weeks. The total legal cost was $14,300, paid from Diane's own estate. Karen was appointed guardian, which is what Diane would have wanted, but Karen now had to file annual accountings with the court, pay ongoing administrative fees, and obtain court approval for any financial decision above a threshold amount every year, for as long as Diane lived. A durable power of attorney, signed before the stroke, would have cost Diane approximately $250 and taken 1 hour to execute. It would have given Karen immediate, full authority to act on Diane's behalf the moment she became incapacitated. No court, no waiting, no $14,000. Now let us talk about exactly what powers of attorney are and how they work. A power of attorney is a legal document in which you, called the principal, give another person, called the agent or attorney, in fact, legal authority to act on your behalf. The scope of that authority, the timing, and the conditions under which it applies are all defined in the document. There are two types of power of attorney that every adult needs: a financial power of attorney and a healthcare power of attorney. They do different things. You need both. A financial power of attorney gives your agent authority to manage your financial affairs. Depending on how it is drafted, this can include paying bills, managing bank accounts, buying and selling investments, filing tax returns, managing real estate, operating a business, and applying for government benefits, including Medicaid. Without this document, no financial institution is legally permitted to allow another person to act on your behalf, regardless of your relationship to them. Your spouse is not automatically your agent. Your adult children are not automatically your agents. Marriage and family do not create financial authority. There is a critical distinction within financial powers of attorney: the difference between durable and non-durable. A non-durable power of attorney becomes void the moment you become incapacitated, which is precisely when you need it most. A durable power of attorney remains in effect even after you become incapacitated because it contains language specifically stating that it survives your incapacity. This is what you want. This is what Diane did not have. A healthcare power of attorney, sometimes called a healthcare proxy or medical power of attorney, gives your agent authority to make medical decisions on your behalf when you cannot make them yourself. This includes decisions about treatment, surgery, medication, life support, and the conditions under which life-sustaining treatment may be withdrawn. Without a healthcare power of attorney, Hospitals and doctors are in an extremely difficult position. They want to involve family members, and most do so informally, but legally, they are not required to follow your family's instructions, and in cases of disagreement among family members, they often cannot. I have heard from families where two siblings disagreed about a parent's treatment and the hospital was left in the middle with no legal document to resolve the conflict. Courts had to intervene. Doctors had to delay decisions. The patient suffered consequences that could have been prevented. Some states have laws that create a default hierarchy, spouse first, then adult children, then parents, and so on for healthcare decision-making when no document exists. But that hierarchy can be challenged, it can create conflict, and it does not give anyone the full authority that a properly executed healthcare power of attorney provides. There is one more concept worth understanding before we get to mistakes: the springing power of attorney. A springing power of attorney is one that does not take effect immediately when you sign it. Instead, it springs into effect only when a specific triggering condition is met, typically a physician's certification that you are incapacitated. Some people prefer this because they are uncomfortable with an agent having immediate authority over their finances while they are still competent. The concern is understandable. The problem is practical. When an emergency happens, you do not always have time to obtain a physician certification before action needs to be taken. Banks can and do delay honoring a springing power of attorney while they verify the certification. Days pass. Bills do not get paid. Decisions do not get made. Most estate planning attorneys recommend a durable power of attorney that takes effect immediately rather than a springing version, because the moment of incapacity is exactly when speed matters most. If you are worried about your agent having too much authority while you are still healthy, the better solution is to choose an agent you trust completely and to be specific in the document about what authority they have and do not have. Limit the scope if you choose, but do not create procedural barriers that will slow down your family at the worst possible moment. I also want to address something that comes up frequently. What happens when there is no one to name as agent? No spouse, no adult children, no close friend who you trust enough? This is more common than people acknowledge, particularly among individuals who are divorced, estranged from family, or who have outlived close relatives. In these situations, some states allow you to name a professional fiduciary, a licensed individual or corporate trustee who serves as agent for compensation. Your attorney can help you identify professional fiduciaries in your state. It is not the ideal solution, but it is far better than having no agent and leaving a court to appoint a stranger. Now, let me tell you about the mistakes people make with powers of attorney. Mistake 1, not having one at all. This is the most common mistake and the one with the most severe consequences. People assume that because they are married, because they have adult children, because they have a will, or because they have a trust, someone can automatically step in and act for them. None of those things create power of attorney authority. The only thing that creates power of attorney authority is a properly signed power of attorney document. Mistake 2, having one that is outdated or that financial institutions will not accept. Many banks and financial institutions have their own internal policies about which power of attorney documents they will honor. Some refuse documents that are more than a certain number of years old, often 3 to 5 years, on the grounds that the document may no longer reflect the principal's wishes. Some refuse documents that do not include specific language authorizing specific types of transactions. If your power of attorney was drafted 15 years ago and does not include language authorizing your agent to manage retirement accounts or apply for Medicaid benefits, your agent may be blocked from doing exactly what you need them to do. Mistake 3, choosing the wrong agent. Your agent under a financial power of attorney has enormous authority. They can transfer assets. They can make financial decisions that alter your estate significantly. Choosing someone who is not organized, not financially literate, or not someone you trust completely is dangerous. Your agent should be the person who is most capable of acting responsibly under pressure, not necessarily the person who is closest to you emotionally or the one who would be most hurt if left out. Mistake 4, failing to tell your agent where the document is. A power of attorney is useless if no one can find it when they need it. Your agent needs to know the document exists, needs to have a copy, and ideally needs to have already shared it with your bank and financial institutions in advance. Many attorneys recommend filing the financial power of attorney with your bank when it is signed, so there is no delay or dispute when it is needed. Mistake 5, confusing a power of attorney with a living will. A living will, also called an advance directive, is a separate document that records your own wishes about medical treatment in specific circumstances, particularly regarding end-of-life care and life support. It speaks for you directly and does not require an agent to interpret your wishes. A healthcare power of attorney appoints someone to make decisions on your behalf when you cannot speak for yourself. Both documents serve different functions. You should have both. In states that allow it, an advance directive or living will, combined with a healthcare power of attorney, is sometimes called a combined advance directive. The specifics vary by state. What is universal is that having both your own stated wishes and an agent empowered to act gives your family the clearest possible guidance and the strongest legal protection. Now, let me address a question many people have. What if I become incapacitated and I do not have a power of attorney, but I recover? Can I sign one then? Yes, but only if you have regained legal capacity. If you are conscious and cognitively able to understand what you are signing and what authority you are granting, you can execute a power of attorney. The problem is that many incapacity events are sudden and severe. A stroke that causes significant cognitive impairment, a dementia diagnosis that progresses past the point of legal competence, a traumatic brain injury. In those situations, the window to sign may be gone permanently. The time to execute a power of attorney is when you are healthy and fully competent, not when you have just received a diagnosis and not when you are already in the hospital. The cost to have a financial and healthcare power of attorney drafted by an estate planning attorney ranges from $100 to $500 per document, depending on complexity and your location. Many estate planning attorneys offer these documents as part of a broader estate plan that also includes a will or trust. If cost is a concern, legal aid organizations in most states offer power of attorney preparation for low-income individuals at no cost. Some states allow self-preparation using statutory forms, standardized forms that meet the legal requirements of that state. But these should be reviewed by an attorney before signing, as errors in execution can void the document entirely. Your 30-day action plan. Step 1. Check whether you have a durable financial power of attorney. Not just a power of attorney, a durable one. Check the document for the word durable or for language that explicitly states the document survives your incapacity. If you do not have one, or if yours is more than 5 years old, add it to your list for this month. Step 2. Check whether you have a healthcare power of attorney and a living will or advance directive. These are separate documents. Having one does not mean you have the other. Both should name your chosen agent and should reflect your current wishes. Step 3. Review your agent selection. Is your named agent still the right person? Have circumstances changed? A divorce, a death, an estrangement, a change in your agent's own health or financial situation? Your agent should be someone who is physically accessible, emotionally capable of acting under pressure, and someone you would trust with every financial and medical decision in your life. Step 4. Make sure your agent has a copy. Not filed away in a safe deposit box that no one can open without you, a physical copy in your agent's hands, a digital copy stored somewhere accessible, a copy on file with your bank and your doctor. Accessibility at the moment of crisis is what makes the document useful. Step 5. If you do not have these documents, call an estate planning attorney this week. Not this month, this week. You do not know when you will need this. You only know that you will be glad you had it if the time comes, and devastated if your family is left without it. One more thing about step 5. If you already have these documents, give your agent a practice run. Sit down with them and go through where everything is. Your bank accounts, your investment accounts, your insurance policies, your mortgage servicer, your doctor's name, and contact information. The people who will need to be contacted if something happens to you. Your agent having authority on paper means nothing if they do not know where to find the information they need to act on it. The goal is not just to have documents. It is to have a person who is prepared, informed, and capable of protecting you on the day it matters. Diane recovered. She eventually regained enough cognitive function to enjoy her grandchildren and to live at home with some assistance. But Karen will file guardianship paperwork with the court for the rest of Diane's life. Every significant financial decision requires a judge's approval. Diane spent $14,000 to get the same result she could have had for $250. She told her attorney after the fact, "I thought my daughter could just handle things. I did not know I had to give her permission in writing. Now you know, and now you have no reason not to act." If someone you know does not have these documents, a parent, a sibling, a friend who just retired, share this episode with them. It is the most direct thing you can do to protect them. Subscribe to Benefits Decoded. New episode every week covering the decisions that protect your family's future. I am Marcus Webb. Thank you for watching Benefits Decoded. Protect what you built.